Which is why they are saying it is academic, don't deal with it, our speaker will decide, now we have a new speaker, and now we can't remove him because they have the majority now. So even if we give a notice, we can't remove him because they've toppled the government. See the serious consequences of this. And what moral principles are we talking about, Mullahs? These are not conscientious objectors, Mullahs, like in Soviet citizen wars, Mullahs, in Russia. These are conscientious defectors, where they lay their conscience on a platter and depends on who bids the highest. Let's not make these moral principles in this. We know what happens. So, please, brothers, please, I beg of you, this is not about today. This is about tomorrow. Don't board the issue, brothers, and say it doesn't arise. It will arise time and again. Governments, elected governments will be toppled. And no democracy in the world allows this to happen. Why do you allow the party to use the 10th schedule? In fact, the process must be, this is my version when I argue the merits, the process must be that an elected government must continue till the disqualification petitions are decided. If they are disqualified, that's the end of the matter. Your Lordship is there to protect them. If they are not disqualified, the elected government will go. But do not allow the 10th schedule to topple an elected government. And do not interpret 179, 181, the moral principles that Justice Mishra talked about, to allow this to happen. It's far too serious. It's not just a narrow interpretation.
Mr. Sibal, ultimately, equally, what your submission is, therefore, give free rein to the speaker.
No,
to the speaker.
No, Malaj.
Without imposing any restraint.
No. Please don't do that. And I'll tell your Lordship what the solution. What's the free rein, Malaj? He cannot deal with a disqualification unless there is a disqualification petition. He has no right to suo motu deal with it. Malaj, the disqualification petition will come under 2.1a or 2.1b. 2.1a, if he violates the whip, Malaj, what's the free run for the speaker there? In this, what happened? On the 3rd of July, at the time of the election of the speaker, the whip in the house was Sunil Prabhu. He had not been changed. He directed that the Shiv Sena candidate should be voted for by these defectors. They voted against. They elected the BJP candidate, not the Shiv Sena candidate.
Interestingly, both your argument and the argument of the other side, which espouses the Nabam principle, rely on the same principle, namely the importance of the speaker. They say, because of the importance of the position of the speaker, it's important that you must exclude any possibility of conflict of interest.
No, where is the conflict of interest?
You say that in view of the importance of the position of the speaker, allow him to decide.
No, I say don't allow an elected government to be toppled in this fashion. No, don't allow the verdict of the people to be toppled or an elected government to be toppled in this fashion. That's the fundamental principle. A government stands elected till it is removed, and it cannot be removed through the machinations under the 10th schedule. That's my contention. Let's forget about the speaker or no. This is the fundamental principle of democracy. And if you have violated the 10th schedule, allow the speaker to decide. He can't decide contrary. If there's a whip, that has been issued and somebody votes against the whip, what leeway does the speaker have? You are giving a leeway to the other side, disabling him, toppling the government, and then not deciding the matter. I remember, when the Rajasthan matter came up on this court, Justice Arun Mishra, on a daily basis, used to monitor the disqualification proceeding. On a daily basis. When it came to Rajasthan. When it came to Goa, for 2.5 years, we kept on telling the Chief Justice, please have the matter heard, please have the matter heard. Where do we go? These are all nice principles of law, but you have to have a functioning, working democracy.
Rhetoric, not law.
This is why it's far too serious, Manoj. The fundamental principle is keep an elected government that is already elected in place, keep it in place till such time as it can be thrown out. Of course, it should be thrown out, Manoj. And that is not to be decided in the legislature, Manoj. Kindly appreciate what is happening. This is another very interesting thing. And it's something that your lordship should think about. 5 people in Goa, say 2 of them or 3 of them are taken over by another party. The government falls. Or 4 of them are taken. The argument is that under the principle of merger, since they have merged with another party, right? Now, what is the party? The Congress party still remains. Those 3 of only legislators have merged. The party still remains. It happens in the Rajasthan also. The BSP people, Manoj, have merged, but the BSP still remains. So what we are now doing, we are allowing the manipulation within the legislative assembly to topple governments through means that your lordships and I are aware of. The purpose of the 10th schedule was not to allow that to happen. Not to allow that to happen. That was the purpose of the 10th schedule. Previously, it was 1/3 in paragraph 3. They said we removed the 1/3 because it was being used to topple governments. Now there is no paragraph 3. Now a bogey of majority is raised. Because if a minority can be bought, majority can also be bought. But to what end? To topple the government. And not to allow the speaker to decide the matter. Because who can say, person sitting of one party in Guwahati, saying that he has not voluntarily given up membership of the party, it stares you in the face. He is passing resolutions from there that I remove you from chairmanship, I remove you from this office, I remove you from that office, I appoint myself. That's not supposed to be voluntarily giving up party. They are all arguing on the assumption that they are right when they say that there can be no disqualification for these acts. That's how they are arguing. And that the speaker, deputy speaker will malafidely say that they stand disqualified. You can't make a constitutional assumption like that. That's the assumption they are making. See what the speaker is doing. He only gave us 2 days notice. Why did he give you 2 days notice? Because the facts stared him in the face. That's the reason for the 2-day notice. Now, your lordships, when dealing with the merits of the matter, will decide whether that was enough, not enough in the facts of the case, but that's on merits. But the issues are far larger. And if this is allowed, it can happen anywhere, and it will happen. It has happened. This is not the first time. Now, having said that, kindly come to the 10th schedule for a minute. If any question arises as to whether a member of a house has become subject to disqualification under the schedule, the question shall be referred for the decision of the chairman, or as the case may be, the speaker of such house, and such decision shall be final. Provided that where the question which has arisen is as to whether the chairman or the speaker of a house has become subject to such disqualification, not removal, the question shall be referred to for the decision of such member of the house, as the house may elect in this behalf, and his decision shall be final. The constitution makers were aware of the difference between removal and disqualification.
Yes.
They were aware. They never incorporated, as your lordship has said also. When the amendments were taking place during this time, during the 93rd amendment, they never incorporated any of this. And the reason was that when you talked about removal, it was an entirely different regime. And I show that to your lordships, but just refer to the Lok Sabha rules. Chief Justice will tell me I'm not using my iPad, so that I use it. Now, let's kindly see resolution for removal of speaker or deputy speaker from office. Your lordship has that? 200. A member wishing to give notice.
What's the PDF page?
Page 26. 26.
Yes.
Now, let's see on the right-hand side, the bold part. That's the notice of resolution for removal of speaker or deputy speaker. That's just notice. A member wishing to give notice of a resolution under clause C of Article 94 of the Constitution for the removal of the speaker or the deputy speaker shall do so in writing to the Secretary General and shall furnish the full text of such resolution. On receipt of a notice under sub-rule 1, a motion. So that's first is notice, then a motion. My Lord, if I just Narasimha was actually rightly bifurcated that rule in that fashion. On receipt of a notice under sub-rule 1, a motion for leave to move, the resolution shall be entered in the list of business in the name of the member concerned on a day fixed by the speaker, provided that the day so fixed shall be any day after 14 days from the date of the receipt of notice of the resolution.
There is 179
day notice. So, first the notice, then a fixed day for motion. Then, in order that such a resolution, so first of all, notice of resolution, then admissibility of resolution. That's the third stage. In order that such a resolution may be admissible, it shall satisfy the following conditions. Namely, it shall be specific with respect to charges, because removal involves a stigma. That is, Constitution uses the word removal, not a no confidence. But as your Lordship knows, in a no confidence motion, you don't have to give a reason. The House votes and you are out. But in the case of a removal, you have to give reasons. You don't say nabam rebia.